Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare a recess of the committee at any time. Pursuant to notice, I now call up H.R. 4676 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4676, to amend Title 18 United States Code to provide an additional tool to prevent certain fraud against veterans and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. H.R. 4676, the Preventing Crimes Against Veterans Act of 2016, was introduced by Congressman Tom Rooney of Florida, a former member of this committee, and Congressman Ted Deutsch of Florida, a current member of this committee. This legislation fixes a loophole in federal law and provides federal prosecutors with an additional tool to go after criminals who seek to defraud veterans. In recent years, financial predators have increasingly targeted veterans, particularly elderly veterans in low-income housing, in an effort to defraud the veterans out of their Veterans Affairs benefits. These criminals offer to help veterans with their cases, claim to get their benefits approved in record time, charge fees that are often in the thousands of dollars, and then provide them with little or no assistance. Under current law, many of these fraudsters would be vulnerable to prosecution under the mail or wire fraud statutes if they engage in this sort of fraudulent scheme by calling a veteran on the phone, sending them an email, mailing them a letter, or otherwise using the instrumentalities of interstate commerce to commit fraud. However, increasingly, these criminals are taking advantage of a loophole in federal law by conducting in-person seminars or meeting in person at a veteran's home or assisted living facility. In at least one recent example, a fraudster visited an assisted living facility in Florida and asked the staff to take up all the veterans for a seminar. This sort of conduct, swindling an elderly veteran out of his or her benefits, is truly reprehensible and worthy of Congress's attention. H.R. 4676, which has the support of the veteran service community, addresses this conduct. This vulnerable population has done its duty to protect us from harm. It's our duty to help protect them, and I urge my colleagues to support this important legislation, and it's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, I'm pleased to support H.R. 4676, the Preventing Crimes Against Veterans Act. This legislation provides an important additional tool for federal prosecutors to use to combat veterans' benefits fraud. Because we honor their service and because of the sacrifices of our veterans and what they've made for us, it's particularly important that we protect them from fraud and ensure the integrity of the system of benefits we provide for them. Currently, there are about 21 million veterans of the United States military, men and women who selflessly served our nation and in theaters of war, from the Second World War, Korea, and Vietnam, to more recent conflicts in Iraq and Afghanistan. Unfortunately, many of our veterans, as a result of their service, have physical and mental scars. There are well over 1 million American veterans with service-connected disabilities. The suicide rate among veterans, believe it or not, is 300% above the national average, and it is estimated that about 30% of all Vietnam veterans and 20% of veterans of the recent Middle East conflicts suffer from post-traumatic stress disorder in a given year. In addition, veterans are more likely than non-veterans to become homeless. They comprise, believe it or not, 17% of our homeless population. On any given night, an estimated 50,000 veterans are sleeping on America's streets. In recognition of the extreme sacrifice by our veterans and the hardships many of them continue to face after their military service, It's our duty to provide to the best of our ability an appropriate measure of compensation for them, particularly for those in need. For instance, we provide disability payments to those with service-connected disabilities, pensions for veterans with limited incomes, education and training under the GI Bill, and also various life insurance benefits. This is the least that we can do, and it's still not enough. There continue to be issues with the medical care we provide our veterans and problems about some benefits never being processed and paid because of the loss of claims by the Veterans Benefits Administration. Although most of the issues are beyond the reach of the Judiciary Committee, we are able to take action with respect to instances of fraud involving veterans' benefits. H.R. 4676 would make it a crime to knowingly engage in any scheme to defraud a veteran of his or her veterans' benefits, or to knowingly engage in fraud in connection with obtaining veterans' benefits. Anyone convicted of such a crime could be fined, imprisoned, or be subject to both penalties. Those who defraud veterans and the system of veterans' benefits harm the victims and diminish resources required to pay the claims and fund the programs that are needed to help those who have served their country. And accordingly, I join with the chairman in support of H.R. 4676, and I thank the gentleman from Florida, Ted Deutsch, for his leadership on this important measure. I yield back.
Chair thanks the gentleman and is pleased to recognize the gentleman from Florida, Mr. Deutsch, the lead Democrat co-sponsor of the legislation, for his opening remarks.
Thank you, Mr. Chairman. Thank you, Chairman Goodlatte and Ranking Member Conyers, for your commitment to our veterans and for bringing this legislation before our committee today. Briefly, I'd like to recognize my Florida colleague and veteran, Tom Rooney, first for his service to our country, but also to thank him for his ongoing commitment to his fellow veterans through the Preventing Crimes Against Veterans Act that we introduced together. The legislation before us today was born out of the recognition that current law has not kept pace with the growing sophistication of scam artists and fraudsters seeking to take advantage of American veterans. I want to thank Greg Dover of Palm Beach County Veterans Services, who really brought this issue to my attention and has helped make the case for this important legislation. I've heard too many stories of my own constituents, veterans, survivors, and families who have been taken advantage of through so-called pension poaching scams, targeting the supplemental aid and attendance pension benefit. In one case, a veteran responded to a solicitation offering additional pension benefits. A sales representative then visited the veteran at home and used high-pressure tactics to convince the veteran to apply for benefits that they did not want and were not eligible for. In addition to filing the claim, the scammer told the veteran that he was required to enter into a long-term home health care contract to receive the benefits. Pension poachers in South Florida hold briefings in senior communities to find targets. In one case, after attending a briefing, a scammer filed inaccurate claims on behalf of a veteran that did not include spousal income. After the veteran paid excessive filing fees of over $600 for a service that VSOs provide for free, the VA eventually learned that the veteran was not eligible and billed the veteran for nearly $50,000 in overpayments. Meanwhile, the scammer had disappeared and could not be contacted. As our senior populations continue to grow, more and more aging veterans will require assistance with activities of daily living that Veterans Aid and Attendance Benefit can provide. The application and financial eligibility requirements give scam artists an opening to take advantage of our older Americans with empty promises and with hidden consequences. Aging veterans and their families are often tasked with working through difficult health and financial issues, and to do it in stressful circumstances. The need for assistance with navigating the process of applications and appeals can make veterans, survivors, and their families attractive marks to sophisticated fraud artists. Companies and individual scammers seek to build trust in a moment of need in order to sell financial products with no real value. In the end, veterans are left with all of their assets and their life savings out of reach, while earned additional benefits are routed directly to the scammer. The Federal Trade Commission and Florida Division of Consumer Services provide public awareness resources to assist veterans and their families, and veteran service organizations as well, to help them avoid known scams. But there are currently no criminal penalties imposed when scammers violate prohibitions against charging fees for benefit assistance services. This leaves law enforcement and consumer protection agencies with limited resources to combat these schemes. This legislation will provide law enforcement with the tools necessary to fight back against pension poachers and other scammers. It will protect our veterans from falling victim to these ploys, and it is one small but important way for Congress to be there for our veterans after they have dedicated themselves to protecting all of us and our constituents. I urge my fellow committee members to support this legislation. Chairman, again, I thank you, and I yield back.
Chair thanks the gentleman. Without objection, all other members' opening statements will be made a part of the record. And the
Mr. Chairman,
what purpose does the gentleman from Michigan seek recognition?
I have an amendment at the desk and ask that it be reported.
The clerk will report the amendment.
Thank you.
Amendment to H.R. 4676 offered by Mr. Conyers. Page 2, line 3.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman and colleagues. My amendment would ensure that the bill protects not only veterans with respect to veterans benefits fraud, but also punishes those who defraud the dependents and survivors out of benefits they are owed due to the service of a veteran. Going back in history, President Abraham Lincoln, in his second inaugural address toward the end of the Civil War in 1865, eloquently explained the need for our country to guarantee the welfare of our veterans. He called for the nation to care for him who shall have borne the battle, and for his widow and his orphan. My amendment will help us live up to the full challenge issued long ago by President Lincoln. The Veterans Benefit Administration of the Department of Veterans Affairs administers $95 billion in benefits each year. But these programs include more than the benefits provided directly to the veterans themselves. In addition to benefits that veterans receive, the many of these programs provide benefits to surviving spouses and dependent children. For instance, some surviving spouses receive monthly tax-free dependency and indemnity compensation payments, including additional payments for dependent children. And a surviving spouse or the children of a deceased veteran with wartime service may also receive a survivor's pension. And surviving spouses and dependents of veterans with permanent and total service-connected disabilities receive reimbursement for most medical expenses under the Civilian Health and Medical Program of the Department of Veteran Affairs. And some dependents of veterans receive educational assistance benefits. And finally, surviving spouses of veterans may receive certain VA home loan benefits. Just as we have an interest in protecting the veterans themselves from fraud, we should extend any additional protection offered by the bill to these types of benefits and the dependents and surviving spouses of veterans. In so doing, we honor the sacrifices that the families of veterans have made in connection with the service of their family member. I reiterate my support, of course, for the underlying bill and ask that H.R. 4676 be strengthened by these changes. I hope my colleagues will support my amendment. And I yield back the balance of my time, Mr. Chairman. Thank you.
Chair thanks the gentleman and recognizing himself in support of the gentleman's amendment. I appreciate Mr. Conyers offering this amendment. This amendment extends the provisions in H.R. 4676 to cover fraud against other individuals such as a veteran's dependents or surviving spouse. The intent of this bill is to give federal authorities an additional tool to use against criminals who are committing fraud in connection with veterans' benefits. I believe this amendment is in line with that intent. It is entirely reasonable for Congress to extend the protections of this bill to other individuals who may be recipients of veterans' benefits, including dependents and surviving spouses, since they also rely on those benefits. This amendment recognizes that individuals other than veterans can be victims of this criminal activity and broadens the bill's scope to ensure that the bill covers those situations. I support the amendment and urge my colleagues to do the same. The question is on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those opposed, no. Being the chair, the ayes have it, and the amendment is agreed to. Are there any further amendments to H.R. 4676?
If you need just one more by the time you call. Huh? We've got one down the hall, so if you call it, he'll make it. Oh, but they need it in the room, so we're not gonna.
Given the lack of a reporting quorum, further proceedings on H.R. 4676 will be postponed. Pursuant to notice, I now call up H.R. 4771 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4771, to improve patient access to health care services and provide improved medical care by reducing the excessive burden the liability system places on the health care delivery system.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. The bill before us today, known as the Health Act, is modeled on California's highly successful litigation reforms that have lowered health care costs and made health care much more accessible to the people of that state. Because the evidence of the effects of those reforms on lowering health care costs is so overwhelming, the Congressional Budget Office has estimated that if the same reforms were applied at the federal level, they would save $44 billion over a 10-year period. And because the evidence that those reforms increase access to health care is so overwhelming, they are supported by a huge variety of public safety and labor unions, community clinics and health centers, and organizations dedicated to disease prevention, all of whom have seen the beneficial effects of these reforms in California. So popular are these reforms among the citizens of California that a ballot initiative to raise the damages cap backed and funded by trial lawyers was defeated by an over 2-to-1 margin in 2014. The bill before us today is identical to what was reported out of this committee 2 Congresses ago, and the Health Act has passed the House many times because the need for it persists. The Health Act's common sense reforms, including a $250,000 cap on non-economic damages and limits on the contingency fees lawyers can charge. They allow courts to require periodic payments for future damages instead of lump sum awards, so bankruptcies in which plaintiffs would receive only pennies on the dollar can be prevented. They include provisions creating a fair share rule by which damages are allocated fairly in direct proportion to fault and reasonable guidelines, but not caps on the award of punitive damages. And the Health Act does all this without in any way limiting compensation for 100% of plaintiffs' economic losses, which include anything to which a receipt can be attached, including all medical costs, lost wages, future lost wages, rehabilitation costs, and any other economic out-of-pocket loss suffered as a result of a health care injury. Far from limiting deserved recoveries in California, these reforms have led to medical damages awards in deserving cases in the $80 and $90 million range. The Health Act also does not preempt any state law that otherwise caps damages. It's well within Congress's power to enact litigation reforms, and there are many established precedents for doing so. For example, that's what Congress did when it passed the Protection of Unlawful Commerce in Arms Act in 2006, which provides protections from excessive litigation to those in the firearms industry. That federal law was upheld in federal court as coming well within Congress's Commerce Clause authority. And when President Ronald Reagan established a special task force to study the need for federal tort reform, that task force concluded as follows, quote, "In sum, tort law appears to be a major cause of the insurance availability and affordability crisis, which the federal government can and should address in a variety of sensible and appropriate ways. Indeed, the Reagan task force specifically recommended, quote, eliminate joint and several liability, end quote, provide for periodic payments of future economic damages, end quote, schedule, that is, limit contingency fees, end quote, of attorneys, and limit non-economic damages to a fair and reasonable amount, end quote. All these recommended reforms are part of the Health Act. I urge my colleagues to support this legislation to enact common sense litigation reforms in the health care context. And it is now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, today's markup of H.R. 4771 is the 11th time since 1995 that we have considered legislation intended to deny medical malpractice victims the ability to be made whole and to hold wrongdoers accountable. Notwithstanding the fact that this measure has repeatedly failed to become law because of its many problems, the rushed consideration and timing of this markup to me are not a coincidence. We're taking up this bill because so many of the members of the majority cannot keep its members together on what to do about the federal budget. To begin with, H.R. 4771 is a solution in search of a non-existent problem. Although the bill's proponents claim too many medical malpractice lawsuits are driving up medical malpractice premiums, the facts do not support this claim. It is not the frequency of legislation or the size of the jury awards that determines medical malpractice insurance premiums. Rather, insurance premiums are largely driven by the investment practices of insurance companies that invest premium dollars for maximum return. So when the stock market plummets or interest rates drop, insurers sharply increase premiums and reduce coverage. H.R. 4771 does nothing to address this boom and bust cycle in the investment practices of the insurance industry. And it does nothing to address the McCarran-Ferguson's Act unjustified antitrust exemption for, quote, business of insurance, end quotation, repeal of which would go a long way towards stabilizing the medical malpractice insurance market. There's simply no evidence that premiums are going up because of malpractice lawsuits. While not addressing a real harm, this bill would cause real harm by severely limiting the ability of victims to be made whole. The bill would cause real harm by severely limiting the ability of victims to be made whole. For instance, it imposes an unjustifiably low cap on non-economic damages. The bill's $250,000 limit for non-economic damages and an amount established more than 40 years ago pursuant to a California statute would have a disparately adverse impact on women, children, the poor, and other vulnerable members of society. These groups are more likely to receive non-economic damages in medical malpractice cases because they are less able to establish lost wages and other economic losses. For instance, women recover lower amounts in economic damages than men because they receive lower overall wages. And not surprisingly, they are 3 times more likely than men to receive non-economic damages. Women are also more likely to suffer non-economic loss, like disfigurement or loss of fertility, or to be the victim of conduct that is likely to lead to punitive damages such as sexual assault. These harms are further heightened by the bill's new burdens on proving punitive damages and its expansive application to all health care lawsuits, not just medical malpractice suits. Whatever the short-term savings, the bill would impose broad social and financial costs in the long term, including the additional strains on Medicare, Medicaid, and other programs caused when malpractice victims are denied full restitution. And finally, the bill represents a deep intrusion into state sovereignty. As any beginning law student knows, tort law is supposed to be the domain of the states. Yet this bill preempts medical malpractice and product liability in all 50 states to protect insurance companies, providers, pharmaceutical manufacturers, all at the expense of victims. And so accordingly, I oppose H.R. 4771 for these many reasons and hope that the committee will join me in rejecting this bill. Thank you, Mr. Chairman.
Chair, thanks, gentlemen. Are there any amendments to H.R. 4771?
Yes, sir, I have an amendment.
Oh, I'm sorry. We actually have
Oh,
another.
yes.
The chair recognizes the gentleman from Arizona, the chairman of the Constitution Subcommittee, for his opening statement.
Well, thank you, Mr. Chairman. And Mr. Chairman, I think you've very adequately discussed the policy basis for the bill before us today. But as chairman of the House Subcommittee on the Constitution and Civil Justice, I'd like to take a moment to discuss how the Health Act furthers the goals of the founders who supported the authority of Congress under the Constitution to break down state-imposed barriers to trade nationwide. The principal architects and advocates of the federal Constitution, James Madison and Alexander Hamilton, made it clear in the Federalist Papers that Congress has the constitutional authority to enact legislation that breaks down the types of barriers to trade and free enterprise caused by excessive and abused state tort laws. In a letter to Thomas Jefferson, James Madison called the Federalist Papers, quote, the most authentic exposition of the text of the federal Constitution as understood by the body which prepared it and the authority which accepted it, unquote. And what did Hamilton and Madison have to say in the Federalist Papers about the proper understanding of the Constitution's Commerce Clause, which grants Congress the power to regulate commerce among the several states? The Commerce Clause, they wrote, was necessary to allow Congress the ability to provide for the free flow of goods and services nationwide. As Hamilton wrote in Federalist number 11, quote, an unrestrained intercourse between the states themselves will advance the trade of each by an interchange of their respective productions. The veins of commerce in every part will be replenished and will acquire additional motion and vigor from free circulation of the commodities of every part, unquote. In Federalist number 12, Hamilton wrote that Congress's authority to protect the free flow of services nationwide was necessary for, and I quote, multiplying the means of gratification it serves to vivify and invigorate the channels of industry, and to make them flow with greater activity and copiousness. The assiduous merchant, the laborious husbandman, the active mechanic, and the industrious manufacturer, all orders of men, look forward with eager expectation and growing alacrity to this pleasing reward of their toils, unquote. Further, Mr. Chairman, the Commerce Clause was necessary to allow Congress to counter not only the sorts of state-imposed barriers that increased prices in existence at that time, namely state-imposed duties on things that came within their borders, but also future trade barriers, the nature of which would change with time. As Madison wrote in Federalist number 42, quote, we may be assured by past experience that such a practice would be introduced by future contrivances, unquote, if Congress did not have the authority to break down barriers to trade imposed by the states. Now, Mr. Chairman, how does all of this relate to modern tort law? In Federalist number 42, Madison wrote, the Commerce Clause is necessary to allow Congress to counter, quote, future contrivances in the states that limit the free flow of goods and services nationwide. One such future contrivance is the vast expansion of tort liability in the states, along with its abuse and the adverse economic effects of such an expansion. That's occurred since 1789. As legal historian Lawrence Friedman describes the current situation, quote, the dramatic extension of the tort system in the 20th century is unquestionably real. People brought lawsuits which would have been unthinkable in the 19th century or even in the early part of the 20th, unquote. State tort law has dramatically and negatively affected interstate movement of individuals with valuable skills. Studies show that medical liability laws have a significant effect on the movement of medical professionals from state to state. Not surprisingly, studies also show that Mississippi and Texas, two states that enacted medical tort reforms recently, have experienced a significant rise in the number of doctors practicing there. Congress has the clear authority under the Commerce Clause to enact federal tort reform that facilitates the free movement of medical professionals throughout all 50 states, unimpeded by the deterrent effects of excessive tort liability. Such excessive tort liability also costs federal taxpayers billions of dollars. The Congressional Budget Office pronounced that a legal reform package modeled on the Health Act would reduce the federal budget by tens of billions of dollars over the next 10 years. And, of course, Mr. Chairman, that's a conservative estimate. According to another CBO report, CBO estimates that under the Health Act, premiums for medical malpractice insurance ultimately would be an average of 25 to 30% below what they would have been under current law. That would translate into many more doctors nationwide. And for those and other reasons, Mr. Chairman, I would urge all my colleagues to support this vital legislation.
Mr. Chairman,
For purpose, the gentleman from New York seek recognition.
strike the last word.
Gentleman's recognized for 5 minutes.
Thank you. I just want to comment briefly on some of the remarks we just heard. Essentially, what we just heard is that the expansion of tort law inhibits, if I interpreted it correctly, inhibits the free flow of doctors from state to state, and presumably inhibits the number of doctors in practice, and therefore harms society in general. Now, no evidence is offered for this assertion, and one might think that there are other barriers to practice, like licensing requirements and education requirements, which might have an impact on this. And before evaluating the assertions we heard today, one might have to take a look at that. And then finally, we heard, and this brings back an earlier series of debates in this committee, that if we pass this legislation, medical costs would go down by 25%. I remember sitting here in this very room dealing for 8 years with bankruptcy legislation. And we were told if we passed the bankruptcy legislation, which unfortunately we did in 2005, that the average consumer would save $400 a year in lower interest costs, because the banks would pass on the savings as a result of the bankruptcy legislation, that they wouldn't be giving money to all these moochers, all these middle-class moochers, and they would pass on the savings in the form of lower interest rates. Well, what happened? We severely injured lower and middle-class people in extremist and bankruptcy situations. I don't recall any lowering of interest rates by banks, even when the prime rate went way down. I don't recall that consumers benefited in the form of lower interest rates at all. I offered an amendment when we were considering that legislation to mandate that a certain percentage of the savings be passed on in the form of lower interest rates, and of course that amendment was defeated. But when I hear an argument now, unsupported by facts or evidence, that the cost of medical care will go down by X percent, 25%, if we only pass this tort reform legislation, I'm very much reminded of the failure, the predicted failure of the bankruptcy legislation to reduce costs for consumers. And I think this is just as much nonsense as that. I yield back.
Gentleman from Texas is recognized for 5 minutes.
I thank the gentleman. I want to make some comments about this legislation and the way that I see it. The legislation doesn't deal with the federal government's power to regulate lawsuits in federal courts, which we have jurisdiction to do. What this legislation does is goes and tells 15 states that since you do not have a limit on punitive damages, we are going to impose a limit on punitive damages in your state, whether you like it or not. And one state, and the gentleman from New York can correct me if I'm wrong, I believe New York has in their constitution that there will be no limits on punitive damages in lawsuits. I believe that's correct. You can correct me if I'm wrong. But in any event, I think the Commerce Clause is being overly used. I would like to quote Justice Thomas, Clarence Thomas, regarding the Obamacare law. It was a little different. It's a different issue, but it was the Commerce Clause. And he made the comment that, as I've previously explained, the court's continued use of this test has encouraged the federal government to persist in its view that the Commerce Clause has virtually no limits. And this is yet another example of that. The Commerce Clause, it means what we say it means. In any nexus whatsoever, the federal government can come swooping in and control those states. And so I believe that this issue should be left up entirely in the state courts to the states, not to the federal government. Whether it's a good issue or a bad idea to have limits on punitive damages and on tort, on lawsuits, attorney's fees, that's an issue for the states. You know, Texas has done tort reform. We've changed the whole dynamics, as has been mentioned here. But other states, 15 I believe there are, has no limits on punitive damages. That's the right of those people in that state to make that decision, and the federal government, this court or this committee should not, in my opinion, pass legislation that harms state courts and decisions made in state courts because the people of those states don't want limits on liability or regarding punitive damages, and that's their decision to make. So I'm opposed to this legislation because of this provision. It's a state's decision, state's rights decision, if you want to use that phrase. And has the gentleman from New York verified my comment or not about New York?
Well,
I'll yield to the gentleman.
thank you. Let me say I agree with your comments on federalism. I don't know if the New York State Constitution has such a provision.
Regaining my time, we'll find out that issue. But in all due respect to those who are sponsoring this legislation and our discussions about constitutional law, the bottom line is we can make the Commerce Clause apply to any situation where we want to change the law in some state. This is another example of that. I'm opposed to the legislation. It violates the state's prerogative to make that decision on their own. And I'll yield back to the chairman. Yes, I'll yield to the gentleman from New York.
I now have an answer to your question. New York has a provision that says the Constitution says the right of action now existing to recover damages for injuries resulting in death shall never be abrogated, and the amount recoverable shall not be subject to any statutory limitation. That's in the state constitution.
Regaining my time, I thank the gentleman for verifying that. Shows I have absolutely no life. I read the New York Constitution. So I'll yield back to the chairman.
The gentleman yields back. The gentleman from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. I wish to associate myself with the remarks and comments of my friend Judge Poe from the great state of Texas. And I also anticipate the remarks of my friend Judge Louis Gohmert from the great state of Texas. I imagine that I will, if I had the time, I would associate myself with his remarks. And I expect that Judge Gohmert will have the same spirit consistent with Judge Poe. And those are consistent with their long-held beliefs that have been demonstrated throughout the time that I've known them in Congress as strong proponents of states' rights with respect to issues such as this. The proponent of this legislation contends that in order to produce more doctors and the free flow of doctors around the United States, we have to have federal tort reform that would impose a cap on state laws that protect patients from medical errors. Each state has the prerogative to have its own laws and processes by which it protects its citizens. Georgia is one of the 17 states that court rulings have come down opposed to caps on medical malpractice damages. What this legislation would do would be to replace those state laws with a federal law, and it would do so under the Commerce Clause. This is a usurpation of states' rights. It's not consistent with Republican philosophy, and quite frankly, it's an appalling overreach by the federal government, which I think all Republicans as well as Democrats should be against. And so for that reason, I am opposed to this bill and will be submitting an amendment in just a few seconds that will try to protect and preserve the state's 10th Amendment rights to create legislation protecting their citizens from bad apples. And with that, I will yield back.
The gentleman yields back his time. The gentleman from Texas is recognized for 5 minutes.
Thank you, and I want to thank my friend from Georgia. I take it as a great compliment when you invoke my name in saying that you would expect that I would take a consistent position with what I've taken in the past. I take that as a compliment, and I thank the gentleman. And you actually happen to be right. In fact, I was just handed a quote from me back May 12th of 2012. It's in the congressional record. The quote, and I remember saying this, I also know that if the Congress decides we need to start dictating to every state what their state court system can or can't do, then when a far more liberal Congress comes in, they will be able to say, look, you so-called conservative Republicans dictated to the states what their state tort law should be, so now we're going to dictate to the states what we think it should be, and it ends up being a federal takeover of something that's entirely a state system. And I echo the comments of my friend Judge Poe, so I won't have to repeat them, but you know, there's supposed to be a federal nexus, and we don't have an adequate federal nexus other than the Commerce Clause. And in fact, the bill says Congress finds that healthcare and insurance industries are industries affecting interstate commerce, and the healthcare liability litigation systems existing throughout the United States are activities that affect interstate commerce by contributing to the high costs of healthcare and premiums for healthcare liability insurance purchased by healthcare system providers. And actually, I don't have Judge Roberts' opinion directly in front of me. And obviously, hopefully it's obvious to people that Chief Justice Roberts has been very inconsistent in his rulings. But in the case on Obamacare, I don't have to quote from a dissenting opinion, the majority opinion, Chief Justice Roberts pointed out that if you take the Commerce Clause to say that because health care and insurance are so widespread that gives us right under the Commerce Clause to dictate law about it, then you're missing, you're extending the Commerce Clause too far, basically. I like what we did in the way of tort reform in Texas. We had lost doctors in the Valley, South Texas. We had lost health care providers. And there were major verdicts that were getting out of hand, and they were preventing people from getting the health care they needed. So the Texas legislature did a very responsible thing, in my opinion. They passed tort reform, med-mal reform, and doctors came back, hospitals came back, and people began to get health care more like what they needed. So I applaud the Texas legislature for doing that. I've been asked here before, well, don't you want the other states to have the benefits that Texas got after it did tort reform? Well, of course I do. But that's up to the states. And as I've said before, if you have a very liberal state that wants to have such liberal tort laws that it runs every doctor out of the state, I bet you that eventually they'll figure out we need to change the law in our state so that some of those doctors that fled to Texas will come back. But that's up to the state. And so I appreciate, because I know the proponents of this bill, I know their heart, and I know they want to do well, and they want to help the lives of people that are suffering. That's who they are. But because of my beliefs about federalism and 10th Amendment and the little part that Justice Roberts got right in the Obamacare decision, that the Commerce Clause did not extend that far, I think this is a bill too far, though I applaud the proponents and look forward to moving forward. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Are there any other folks on this side of the aisle that seek recognition?
Mr. Chairman?
Whose voice?
Mr. Chairman, I have an amendment at the desk.
Right. We haven't gotten to that point yet, but the gentleman from Louisiana, I think, had indicated. Gentleman's recognized for 5 minutes from Louisiana.
Thank you, Mr. Chairman, and I really hope not to take all of it, but this is a really important issue, and to some extent, I understand the goal. But I think in the process, we do some things that, one, states have already commented and started acting on, but when you have the American Bar Association and its 400,000 members and the National Conference of State Legislatures, which I was a member of for 11 years, voicing concern, I think we ought to stop a minute and heed their concerns. But one of the things I just want to say is, when you look at the cap on damages, what we're talking about is that we're going to treat people differently. So if you were in a car accident and you had to have your leg amputated, we'll let you recover all the damages that a jury awards to you. But if a doctor is the wrongdoer, we're going to cap your damages at $250,000. So just because I lose my leg in a hospital because of malpractice, or I lose it in a car accident, nonetheless, I lost my leg, and damages are damages. But we as a Congress would come in and arbitrarily set a value to the person who is harmed by medical malpractice, and I'm not sure that we want to pit people against each other. And then I'll just close with the big concern is that if for their non-economic damages, we cap it if they have a lifetime of needs, whether it's paralysis, whether it's brain damage, at some point the taxpayer is going to foot the bill for something that someone else did. And I know that at least in Louisiana, you know, that's not something that we pride ourselves on. If someone makes harm someone, they're responsible to make that person whole, not the taxpayer that was at home or at work minding their own business. So I just think from a policy standpoint, we're going down a road that we shouldn't go down. We shouldn't pit two Americans against each other and treat them differently based on who's the wrongdoer or the party at fault. And I just don't think that we should put a cap that would put the taxpayers, the American taxpayers, on the hook for making someone whole for something that someone else did. So I just think we ought to take our time and be really, really careful about what we're attempting to do. And I have not touched the argument. I think Congressman Johnson did a good job of the fact that we are really grasping, I think, and making a stretch to go in and overrule what our states are doing. So with that, Mr. Chairman, I would yield back. Thank you.
Thank you. Gentleman yields back. The chair will recognize himself for 5 minutes, and I will yield to the gentleman from Arizona, Mr. Franks.
And I certainly thank the chair. Mr. Chairman, I'm very sensitive to the arguments that are made on behalf of the 10th Amendment here. I think that there's some legitimate cases that are being made here. I guess there's two things I would like to point out here. Number one, some of the language here in the bill itself seeks desperately to protect the state's rights. In page 23, it says, any issue that is not governed by any provision of law established by or under this act, including state standards of negligence, shall be governed by otherwise applicable state or federal law. Also, this act shall not preempt or supersede any state or federal law that imposes greater procedural or substantive protections for healthcare providers and healthcare organizations from liability, loss, or damages than those provided by this act or create a cause of action. And then finally, no provision of this act shall be construed to preempt any state law, whether effective before, on, or after the date of the enactment of this act, that specifies a particular monetary amount of compensation or compensatory or punitive damages, or the total amount of damages that may be awarded in a health care lawsuit, regardless of whether such monetary amount is greater or lesser than provided for under this act. I just wanted to make sure, Mr. Chairman, that everyone knew about that, and it's important, I think, to point out that in all due respect to the legitimate arguments that have been made here, the last time we voted on this exact language, every Republican on this panel voted yes. And while I want more than I know how to express to protect our Constitution and its 10th Amendment, I think that what has created the disparity here is not the federal government or the states themselves, but the abuse of the tort system in general, and that's what this bill seeks to address. And with that, I would
the gentleman yield
back
for question?
I'll yield for a question.
Yes, isn't it a fact
No, I
that
can't yield. This is not my time. I'm sorry. I'll have to. It's not my time.
Reclaiming my time, I'll be happy to yield to the gentleman from Georgia.
Well, I would ask a question of my friend, the proponent of this legislation. Isn't it true that the exclusions that you just pointed out protect health care providers only and not the patients?
Well, the patient's circumstances are really protected under the general law as it is anyway. This is just the punitive damages, and it just says that if states have enacted punitive damage situations, that this would not go further than that. And with that, Mr. Chairman, I'm going to have to yield back.
Okay. Gentleman yields. I will reclaim my time. I'll yield back, and I'll now recognize the gentleman from California, Mr. Peters, for 5 minutes.
Thank you, Mr. Chairman. I just wanted to say California is one of the states that's dealt with this issue, was on the ballot as recently as last year, and has imposed some limits on the recovery in cases of medical malpractice. And I would like to say that I sympathize with the comments of Mr. Gomert and Judge Poe. I don't see this, however, as an issue of Congress's authority to do this, but I do see it as an issue of deference. And I think each state is better equipped to handle these state law claims than Congress is. So for that reason, I would oppose this legislation. I yield back.
Who seeks recognition? Are there any amendments to H.R. 4771? For purpose, the gentleman from Georgia seek recognition.
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 4771 offered by Mr. Johnson. Page 23, insert.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My first amendment would preserve states' 10th Amendment right to create legislation to protect its citizens against bad actors in the healthcare industry. I would point out that this legislation would impose a federal cap on medical malpractice damages awards for non-economic losses. And the problem is that that's a matter of state law. And in fact, there are 17 states that have declared their medical malpractice damage caps that were imposed by the state legislatures themselves as being unconstitutional. And those states are as follows: Alabama, no limitations. Arizona, no limitations. Arkansas, no limitations. Georgia, my home state, no limitations. Florida, no limitations. Illinois, no limits. Kentucky, no limitations. Missouri, no limits. New Hampshire, no limits. New York, Ohio, Oklahoma, no limits. Oregon, no limitations. Pennsylvania, no limitations. Washington, no limitations. Wisconsin, no limitations. And last but not least, Wyoming, no limitations. These are states that have no limitations on these kinds of damages being awarded. And this legislation would take authority away from those states and impose a one-size-fits-all approach that is rammed down the throats of the states in contravention of the 10th Amendment. This is wrong. It's a power grab. It's a hostile takeover of state law. And who will suffer other than the people themselves? Nobody but the people themselves who are living under those state laws would suffer. And I would just like to point out the fact that Representative Morgan Griffith from West Virginia stated it eloquently when he said about adopting the California model and impose it. He says, completely reversing 400 years of Virginia law, he says there are ways to have tort reform without making it one size fits all from Washington. I couldn't agree more. Professor Randy Barrett, or Randy Barnett, referring to fair weather Federalists, as he calls them, he said, quote, "But tort law, the body of rules by which persons seek damages for injuries to their person and property, has always been regulated by states, not the federal government." Hans von Spakovsky of the Heritage Foundation has stated that Congress has no business and no authority under the Constitution telling states what rules should be governing medical malpractice claims. And also Ken Cuccinelli, former Virginia Attorney General, commenting on a section in a 2011 Senate Republicans' job bill. He stated, quote, "With Senate Bill 197, legislation that would have the federal government dictate how state judges are to try medical malpractice cases and cap what state courts may award, several Republican senators have reminded us that federal impositions on states that run contrary to the U.S. Constitution and to the spirit of federalism have never been the sole prerogative of just Democrats. He's reminding his Republican friends to be consistent with their legislative offerings, to be consistent with Republican philosophy. Senator Mike Lee, commenting on that same bill, Senate Bill 197, he said, quote, there was one portion of this Republican jobs package that would have told state courts applying state law, reviewing state causes of action, that they were subject to certain limits, all in the name of interstate commerce, all because these things, like everything else, have a substantial effect on interstate commerce. I wanted to vote for the bill. Were I a member of the state legislature in the state of Utah, I would have voted for that kind of tort reform, but I couldn't do it because it's not within my power. And so we have noted conservatives who have consistently opposed this kind of legislation that is the same as H.R. 4771. And I think in order to be consistent, Republicans on this panel should vote against this legislation, which, as I say, hurts patients. Bottom line, 98,000 patients die every year from medical errors, and many more are injured. This bill replaces state laws that make whole those families who've lost a loved one due to the delay of an HMO. It'll protect workers who protect workers who have lost wages due to defective medical devices and spouses left to bear costly medical bills due to negligence of a health care provider. That is what my amendment will do, is to protect those people, and I would ask that the members of this panel support that amendment. With that, I yield back.
For purposes, the gentleman from Arizona seek recognition.
Mr. Chairman, I'd like to speak to the amendment. Mr. Chairman, I believe this amendment should be rejected, as ultimately it would largely gut the bill. The Health Act appropriately addresses a national problem because doctors are moving from state to state based on which states have enacted reasonable legal reforms. Doctors should be able to practice anywhere there are patients, not just where certain states have enacted reasonable legal reforms and allow them to practice. As over 20 state Supreme Courts have judicially nullified reasonable litigation management provisions enacted by state legislatures, many of which sought to address the crisis in medical professional liability that reduces patients' access to health care. Consequently, in such states, passage of federal legislation by Congress is the only means of addressing the state's current crisis in medical professional liability and restoring patients' access to health care. As over 20 state Supreme Courts have judicially nullified legal reforms under their state constitutions, and many more may do so unless Congress acts under its Supremacy Clause and Commerce Clause authority to let doctors treat patients wherever they are, not just where states have enacted legal reforms that can be upheld under their state constitutions. It is precisely many state constitutional provisions that state judges are using to deny state citizens the legal reforms they've demanded from their state legislature, but which state judges have thwarted through the judicial system. Mr. Chairman, the Commerce Clause allows Congress to enact uniform rules regarding commercial activities, whether or not a state provision is in its Constitution or in its statutory code. And adopting this amendment would result in a hopeless patchwork of rules that would gut the health care cost savings of the bill, and I would urge all of my colleagues to oppose the amendment.
Chair, thanks, gentlemen. For purposes, gentleman from New York seek recognition.
To strike the last word on the amendment.
Gentleman's recognized for 5 minutes.
Yeah, I won't take 5 minutes. I just want to observe a couple of things. We've heard repeatedly The doctors are moving from state to state because of various tort laws in the states. We've seen no documentation of this, no evidence of this, just the bald assertion. And coming from a state with a reasonable tort law in New York, I haven't seen any evidence of that, number one. And number two, the fact that a state has in its constitution, the fact that state courts have enforced their state constitutions is not an argument for overruling their state constitutions in an area the federal government shouldn't get into. Now, I agree. It may be constitutional. This legislation may be constitutional under the Commerce Clause. It doesn't mean that it is wise. It doesn't mean that we should preempt state law in local areas unless there's a very good showing of a nationwide or an extra state effect, of which there's been no showing at all. So the fact that state courts have used state constitutions to nullify state laws just shows that the state courts are doing their job, and is not an argument for the federal courts, for the federal government to step in and say, we want to overrule these state constitutions. I yield back.
The chair recognizes himself for the purpose of placing in the record this document. It says medical tort laws have a dramatic effect on the movement of medical professionals between the states. A study by Mr. Cho and Mr. Losasso, practice location choice by new physicians, the importance of medical malpractice premiums, damage caps, and health professional shortage area designation, 44 Health Services Research 1271. Without objection, will be made a part of the record.
Mr. Chairman.
For the purpose, the gentleman from Michigan seek recognition.
I rise in support of the amendment. The Johnson Amendment exempts any state constitutional provisions from preemption. I support this notion because it would prevent the preemption of any state constitutional provisions that might be preempted by this bill. And this measure, like many of the civil justice bills we've considered, represents a deep intrusion into state sovereignty and demonstrates a strong disrespect for federalism. And I'd like unanimous consent to put into the record from the American Bar Association their concerns regarding this measure 4771.
Without objection, it will be made a part of the record.
And in addition, my colleagues, I'd like you to examine the fact that myself and Chairman Goodlatte have received notification from 30 different organizations that oppose 4771, starting with the Alliance for Justice and going all the way through alphabetically to USPIRG, PIRG. And I'd like that to be
Without objection, it will be made a part of the record.
And then I'd like the members of the committee to know that the National Conference of State Legislators have also gone on record as opposing this measure. And we think that it's important that you know that their opposition will extend to any bill or amendment that preempts any state law governing the awarding of damages by mandatory uniform amounts or the awarding of attorney's fees. And so this to me is a overwhelming consensus among those in our legal association, in our legislatures, who have examined this measure before us and have found that it is not appropriate. And I ask unanimous consent that the National Conference of State Legislatures have their opposition to the measure included in the record.
Without objection, we made a part of the record.
And I will yield back the balance of my time.
Chair thanks the gentleman. Who seeks recognition? The committee does not have a working quorum, and so we'll stand in recess until 1 o'clock.
Committee will come to order. Unfortunately, due to a number of scheduling conflicts, it does not appear that we will be able to reach a working or reporting quorum this afternoon in order to resume the committee's business on the two bills under consideration today. Accordingly, I would ask unanimous consent that the committee do now adjourn. Hearing no objection, the committee now stands adjourned.